Aaron Maduff, thanks for joining us again on the Illinois Channel. We wanted to get an update on the suits that are being brought against the state relative to the state's efforts to lower the cost of the pensions. And if you could give us an update, there was a hearing, as we understand it, today in Sangamon County. What are the highlights of what went on in the chambers today?
When last we were before the court on, I believe it was May 14th, the court wanted to set a schedule, and it wanted to start with the certification motions for class certification. There are 5 cases that are pending before the court. SUAAs is one of them. The other cases all had made allegations in their complaints to have classes that they would represent. We made the determination not to seek class certification when we filed our complaint. We felt that it was unnecessary because if the law is unconstitutional, it's unconstitutional, it falls, and we didn't need to represent a class to do that. We were also concerned that it would take a great deal of time, maybe months, to get through the class certification process before we got into the substance of the case. However, the other 4 cases did have class allegations, so the court had ordered that the parties deal with that first. I believe the court was probably expecting the class certification motions. However, the other 4 cases, the plaintiffs in them came to the conclusion that we had. They came around to our way of thinking, and instead of filing motions to certify the class, they filed a joint motion, which we joined, although we didn't have class allegations, to withdraw the class allegations from the complaint. The state did not object. The court granted that. The court noted that that was probably a wise decision. That substantially shortens the case. It probably takes a couple of months off of what needs to be done, and it allows us to focus on the case going forward. At this point, the question was how to proceed. The plaintiffs' groups generally felt that the first thing we should do is address a motion for summary judgment on the pension protection clause.
Now, let me ask, who is offering the motion for summary judgment?
A joint motion was filed by all 5 plaintiffs' groups, SUA having signed on to it as one of them.
And because a lot of people don't understand some of this phraseology, explain just briefly what is a motion for summary judgment.
Sure. A motion for summary judgment is a motion that says, look, Judge, you have all of the information you need to have. We don't have to go through evidence. We all agree on the facts. Let's simply take a look at the law and make the determination on the legal issues.
Which would have just said, you're right, I'm going to look at the evidence, boom, you guys lose, and the case is over.
No, there was no evidence to look at. What I mean by that
in other words, he could have just ruled, but that's a summary judgment, but you're not...
Without a trial.
Without a trial. There's not going to be summary judgment.
Well, there may be, but the motion for summary judgment was filed on the pension protection clause, but it is not going to be ruled on by the court. The plaintiff's view was that the pension protection clause is not subject to the sovereign powers defense. Other things may be. The state may
Can I, because I kind of want to lay this out. It's not necessarily as complex as sometimes it seems, but I want to kind of go through it slow.
Sure.
There's basically 2 arguments. The state's saying that they can lower, and they have their whole set of arguments as to why they can lower it. And the Constitution says that pensions cannot be diminished. So the state's argument is generally, and I want you to use the phraseology that they would use, I sometimes use the police powers, the sovereign powers. Can you just lay out, irrespective of the merits of that argument, what is that argument?
All right. Let's be clear on what we have here. There are actually several counts. We have claimed, SUA has claimed, that it violates the Pension Protection Clause, which is Article 13, Section 5, that it violates the Contracts Clause, which is Article 1, Section 16, and that it violates the Takings or Eminent Domain Clause, Article 1, Section 15. One of the other complaints also claims that it violates the Equal Protection Clause. However, the question is whether the law is constitutional at all. It may fall because it violates any one of these sections. The Pension Protection Clause is special because we believe that it is not subject to a defense of the police powers, as you would call it, that the state simply cannot, no matter how bad the fiscal state is, cannot violate the Pension Protection Clause. So what happened was that the plaintiffs' groups filed a joint motion saying, Judge, rule on this threshold issue, because if you agree with us that the state cannot violate it by using its police powers at all, then we don't need to go through the exercise of the discovery and presenting evidence that would show that the police powers is necessary and reasonable to use in this circumstance. If that had happened, the court could have ruled in favor of the plaintiffs, found the law unconstitutional, sent it up, and the Supreme Court, if it affirmed, the case would be over. The court's concern, however, is that it could do that, send it up, the Supreme Court reverses and says, no, the police powers can be applied, and then we have to come back down and start over with the evidence. So what the court determined to do was to say, I want to deal with all arguments, all issues. We're going to go through discovery. We're going to take summary judgment motions by both sides on whether or not the police powers apply, on assuming they do apply, whether or not they're necessary and proper, whether or not they're necessary and proper such that they permit the state to violate the Pension Protection Clause, whether or not they're necessary and proper such that they permit the state to violate the Contracts Clause or any other clause of the Constitution, so that we can send it, in the judge's words, as a complete package up to the Supreme Court, and the Supreme Court can pick and choose and make its final determination with all the permutations before it, and it does not come back down to this judge.
And what I wanted to get is just, and that was very good, but I wanted to get now the police powers argument is, if I would say as a layman, basically the state would say our highest duty is to maintain, let's say, law and order.
Sure.
And we are being so economically diminished as a state by having to pay the current level of pensions that we can't necessarily protect society, and that the police powers aspect of the sovereign nature of the state trumps other issues. That's what they would argue, and you would say, no, it doesn't.
You've got the argument exactly right. I think you phrased it very, very well. What our view is twofold. First, the Pension Protection Clause was passed as part of the Constitution in 1970 because the retirement funds were underfunded, and people were concerned that the state might raise the police powers and therefore say we're not going to pay pensions. So at the time, that was exactly what was in the framers' minds when they added Article 13, Section 5 to the Illinois Constitution. Therefore, our view is that that particular section specifically prohibits use of the police powers to violate it. And therefore, the police powers argument should not even be heard as to the Pension Protection Clause. Now, if the court determines that we're wrong on that it can be heard, the state still has to show that the situation is such that it is necessary and reasonable to violate the Pension Protection Clause, the Contracts Clause, the Takings Clause, and as one of the other cases claims, the Equal Protection Clause. And we don't believe that it is necessary and reasonable and that the state has done everything else in its power to ameliorate the situation that it's facing.
I want to come back to some of those issues, but let's go through where we are now. What is the schedule? Because people are going to be, if I can make an analogy, is what I understand. People, from looking at TV shows, they think, well, it's before the court and it's being argued. It's actually more at this point almost like the investigation into the issues, if I might. It's almost like the detective work that's going to gather the information, and it's going to take some months to gather that evidence before the case then is argued before a judge. Is that correct? Yeah,
I think that we as Americans are accustomed to 1 hour Law and Order shows where you go from the police look at a crime, and by the end of the hour you've watched a trial. Well, the real world doesn't work that way. Maybe the real world doesn't make for perfect television. But what happens is that you file a case. You have an answer to the filing that can take a month. You have what we call discovery. What is it that the state has? What is it that we have, so that we can all understand the issues? There are a lot of things that we do outside of court. We will come into the court for guidance, for scheduling, and various issues. And eventually, once we have put all of the information together, then we bundle it up in a package for the court with the legal briefs and explanations. The court reads the legal briefs, and eventually we have an oral argument in most cases, not all, and the court will issue its ruling. The steps that have to come before are such that we probably won't be seeing those legal briefs now on the summary judgment motions until early next year, and it's even possible that if the court finds that there is factual issues in dispute, that it will actually hold evidentiary hearings, hear testimony, and make determinations as to what the facts really are. That's a trial. And what you see on television is just the trial part. Most cases don't end up in a trial. But that's what happens if you have factual disputes, and the court will have to resolve those.
Okay, so now then I had a couple questions relative to when you were arguing. And unlike the U.S. Constitution, the Constitution of Illinois, as you noted, I mean, it was written in 1970. We talk about the founders of the U.S. Constitution. We think of guys like Ben Franklin, who have been long dead. But the delegates who attended the Constitution in 1970, a number of them are still around. People like Mike Madigan. Now, would one go to original intent as you would in perhaps arguing in a case on the U.S. Constitution? And if you were going to argue original intent of the founders of the current Constitution, might one ask someone like a Mike Madigan, who was a delegate to the Constitutional Convention of 1970, to come in and testify to say, what was the original intent when you put in the diminishment clause relative to the pensions?
The short answer is absolutely not. Let me start with why we have a Constitution in 1970. The Illinois Constitution goes back many years. The state of Illinois was a state long before 1970. Many people were living in the state of Illinois before 1970. But the Illinois Constitution sets up the possibility of a constitutional convention every 10 years. The prior Constitution, I believe, was 1870. In 1970, Illinois determined to have that constitutional convention and redid its constitution. So we were operating prior to 1970 on a former constitution, one that did not have a pension protection clause. But we don't have everybody who was a delegate to the Constitutional Convention in 1970. And we know that it had to take a lot of people to vote. And I think, depending upon the particular portion, certain amendments you need a majority, some things you need a supermajority of 2/3 or 60%. I don't have it all memorized. But you can't go ask one person, what did you mean? What you have to look at is what was put into the record at the time. Because even after the delegates vote on it, the Constitution is put to the people of the state of Illinois. If you want to go get testimony, what you need to do is ask every single person who voted in favor of that Constitution in 1970. Well, I guarantee you that somebody isn't around.
Well, I think you might be able to take the transcripts of the actual, I mean, I don't know that we would actually do it from
That's
voters,
exactly
but you might look at the transcripts of when they argued that point to say what was the intent of that, because don't you have to get to what is the legal meaning behind the words? I mean,
that you are absolutely correct on. That's where you go. We look at the transcripts of what the delegates who sponsored it said, what the arguments were, what the opposition was. What does this mean? What was the material that was published to people when they voted on it, so that we know what they understood it to mean? Those are the documents that we look at for legislative, or in this case, constitutional intent.
I'm curious too, when you are arguing before this case, and let's say it goes before the Illinois Supreme Court as anticipated, do you have to narrowly stay within the legal precedents of the court of the Illinois Supreme Court, or can you look for precedents that might have been decided in some other state, or perhaps a pension issue that might have been decided on the federal level?
The answer is that anything that's been decided by the Illinois Supreme Court is binding, certainly on the trial court. The Illinois Supreme Court justices can decide what they thought they meant, but what's written there is binding on the trial court. We do have cases from other states. The state of Arizona recently had a very similar issue, and the Arizona Constitution is very similar on this issue, and the Supreme Court of Arizona found that it was unconstitutional in violation of their pension protection clause. That is not binding on this trial court. It's certainly not binding on the Supreme Court of Illinois. But it does show that the Supreme Court justices in Arizona carefully considered it. It has their arguments, and it can have what we call persuasive value. So we'll certainly present that to the court, and the court will take that into consideration. And we hope, will look at it and say the Supreme Court of Arizona had some wise people on it who thought this through carefully, and we agree with the conclusions that they made. Their Constitution has the same language. We believe that we should come to the same conclusion.
All right, and well, at least now we know after today's hearing that we're not going to have the class action. We're saving months of work there, and the case is progressing, and it may go to before a court sometime in the early to mid-spring of 2015. Is that about the summary?
Well, to be clear, it may go to arguments before the court. It may be packaged for summary judgment proceedings, but the court still has control of the case. We will indeed be appearing before the court. Right now it's scheduled for July the 22nd, I believe, for what we call status, so that we can tell the court where we are, what our progress is. The court can make changes as he so chooses. The judge has wide discretion to do as he chooses in this case.
All right, Aaron Maduff, thanks for joining us.
Thank you.
You're watching the Illinois Channel.